Coming up on the live and interactive ACSA legislative lunch break, Michael and I will get you all of your latest news and information from the state capitol and CDE with an in-depth analysis on how it impacts you. Plus, our main topic today is that Supreme Court decision on parental notification of transgender students. We have our experts in the field, our legal experts on the show today to tell you about the implications for school districts.
It's Wednesday at 1 o'clock. You know what time it is. The ACSA legislative lunch break starts right now.
And it's just after 1 o'clock. We welcome you on a Wednesday to the live and interactive ACSA legislative lunch break. I'm Naj Ali Khan, ACSA's Senior Director of Marketing and Communications, joined today by Michael Kelly, our new media manager. Welcome. Happy Wednesday. So much to get to on this show today. Lots of great information coming your way on that Supreme Court decision. Michael, you are in the seat today because Edgar, fingers crossed, we're going to be talking to Edgar. Edgar's been down in Southern California at the Capitol conference.
Edgar will join us. I have all the faith in the world in Edgar. We did a quick tech check with him. Might be audio only, but you're still going to get to hear from the executive director. I will tell you, it's been a busy 36 hours for us since that Supreme Court ruling came down on Monday night. And there's a lot to discuss today for sure.
This is one of those rulings where the number of attorneys who could speak to it was very small. That population was very small. However, we are going to talk with the lead attorney on this, working for F3 Law. He's been presenting all day on this specific topic. So he's coming right out of those meetings to deliver some really impactful information. So we'll deliver that to you. Jason Engel, first on our board today in our comment section. Lance Bradley, communications professional over at Yucaipa-Calimesa Unified School District, and Christy Espino. So good to have you guys here with us. Lots of information. Let's go ahead and let's get to our main news headline. And again, this will be our focus today. On Monday, the U.S. Supreme Court blocked California's ban on parental notification specifically for transgender students, essentially reinstating a federal district court decision that said parents have a constitutional right to be informed of what their students are doing with respect to gender identification. The court granted an emergency appeal to a conservative group, and now with a 6-3 vote, schools must disclose to parents if their student or students change their pronouns or gender expressing at school. This decision runs counter to California's Safety Act, which was approved and signed into law in 2025. The Safety Act, of course, prohibits school districts from enforcing policies that require teachers to disclose a student's gender identity or sexual orientation to parents without the student's consent. So again, we'll be talking, Michael, with our friends over at F3 Law. Again, they have been presenting today on this subject matter. 36 hours, you said it, Michael. It's been a very, very busy 36 hours since this came out, in the education community really trying to understand what the implications are going to be.
Yeah, I think there's so many questions, and that's something that we'll certainly dive into with David Mishuk when he joins the show, because let's face it, California for so long has been on the forefront of transgender rights, especially for young people. To say this Supreme Court ruling was shocking, that's just not the case, at least to me and to you. I know we've spoken about it off the air. It was expected, given what we know about the Supreme Court, but it doesn't make it any less devastating for our transgender students in California public schools.
Yeah, certainly impactful for our transgender students. And again, we'll talk with F3 in just a moment. I mentioned right at the top of the show, my co-host, Dr. Edgar Zazweta, our executive director here at ACSA, has been traveling, was down at the Capitol conference in Southern California. We wanted to get some of his thoughts, so we're bringing him in live just off a plane from Sacramento International Airport. Edgar, you are audio only, which is fine. Just want to get your initial thoughts on this Supreme Court decision and what this means here for California public education and our great educators.
Inaj, Michael, thanks for filling in for me today. And I was just I was just worried that I was gonna be disheveled after the plane. So that's why we're doing audio. But no, I mean, I was a little, you guys don't catch me a break here. I was like, no, I was like, I don't know that I'm gonna make it. The plane is still in the air, but it worked out. So I'm glad to
People
jump
want
in
to hear
there.
from Edgar.
Yeah, people want to hear from you, boss.
Yeah, no, as you said, Dodge, and I caught the first part of the intro here. Yeah, I've been down at the California Association Asian and Pacific Island Administrators Conference here for the last couple of days, and so this was a topic of conversation. As you just said, I think California here has the reputation of kind of leading the country here on some of these issues, namely AB 1955, which is the focus of this Supreme Court ruling. And I heard Michael say, not a huge surprise in terms of just where the federal government was going to be on it, right? I think we talked about it earlier in the year, how there was a complaint from the federal Department of Education around our state law, and then Trump has brought it up and other officials have brought it up. So that was not a huge surprise. I think now as this entered the legal realm, and I have to say I'm glad that we have our legal friends here to explain all the ups and downs, because this has been, I mean, I think this is like the third iteration of a decision, if I'm not mistaken. Went to a lower court. They put a hold on the California law. The Ninth Circuit, I believe, uh, put it back into place. Now we have the Supreme Court essentially saying that there's yet another injunction under hold on. So I think one of the questions that I know will get clarified here is like, what's next? I think for us, it's really, yeah, I think that's the toughest part, right? And I'll get into like the bigger issues of why AXA even jumped into this to begin with. And one of those was clarity, just because there was a mismatch of policies and directions across the state in terms of board resolutions. Some board resolutions saying that that they put prohibition against outing students, others saying that you couldn't do that, right? So there was just a very fragmented landscape. So I think getting some clarity there under the state law was a big premise for us. It was a big objective. But also, I think more importantly, is that the privacy, the safety, the well-being of students, and we I think we had a number of shows on this very topic. We wanted to be sensitive to those populations where it might not be safe for them to not have these protections and these privacy, especially without their consent. And I think that's ultimately why we as an organization, our board, took action on this. It was really trying to keep those rights of the students at the forefront, while also giving some clarity around the state in terms of what is the direction, what are we supposed to do. I think it's fair to say, as you noted, that right now the big takeaway is there's probably lack of clarity, because what happens now, I don't believe that this is final yet in terms of the court decision, that there could still be litigation. On the plane, I was actually reading that there's some other states. I think the court is considering potentially some other cases that have similar laws or similar cases or around the similar circumstances. So there might be more further action from the Supreme Court. I think just given the track record, I think it's fair to say that we can make some assumptions of where the court may land should there be a final ruling on this. But I think for us, one of the things that we're going to be looking for, and I know sometimes this is a big ask, is for our state leaders. Okay, given this kind of now inconsistency in terms of our state law and these federal rulings, the most important question for our school leaders is going to be, now what, right? And I know that's a place where we're going to have to push on our state, given this complex legal landscape. What's the guidance that we're going to give our folks as they're trying to operate schools every day?
And we'll get some more clarification on that when we talk with David Mishuk of F3 Law a little bit later in the show. We've talked about it throughout, Edgar, that California, look, it still has existing laws requiring teachers to use students' preferred pronouns. Schools are required to offer gender-neutral bathrooms. Sports teams and clubs must be open to all students. All of those remain in place in spite of the Supreme Court ruling. I wonder, from your perspective, what you're hearing from our members, having spent a couple days with them at Capitol. Edgar, do we still have you? We may have lost Edgar.
We may have lost him. I keep just trying to check the audio. It looks like we have lost him, but Edgar was live over at Sac International Airport. Had just gotten off a plane, was in Southern California from the Capitol Conference, but was able to join us audio only, like the days of radio, Michael, here on the live and interactive.
I think I'm back. I
Oh,
didn't
there
hear
we
any of the
go. All
question.
right. The boss is back. Go for
Our guy
it.
is back.
Did you hear Michael's question?
Did you hear my question, Edgar?
Let's try one last time.
Did you hear my question, Edgar?
I didn't. I'm sorry, I did not.
That's okay. So I think, as we were talking about, there's certainly rules around transgender rights, laws around transgender rights in California that still remain intact in spite of the Supreme Court's ruling. But you have spent a couple of days with our members at Capitol. What are you hearing from them about just their overall feelings on the issue?
Yeah, I think there's always this delicate balance, and while we're always trying to meet our legal obligations as a system, and I know I'm speaking for our members, that obviously is something they take very seriously. I know the other piece that they take just as seriously, if not more seriously, is the well-being of our students, right? And I think that's the piece, the big takeaway, that even while you could have inconsistent rulings or whatnot, I think there's an overwhelming commitment when dealing with this population of students who obviously has unique needs, and that we have to take extra care to make sure that we're doing what's in their best interest, even while still trying to apply sometimes these complex laws. And what does it actually mean in practice? What does it mean for a principal who's just trying to run a school every day, or assistant principal, or those at the district office? So I think the big takeaway from hearing from our members is that the work continues, and really trying to put their interests first is what's paramount right now.
All right. Dr. Edgar Zazwata, ACSA's executive director, live for us from Sac International Airport, just coming off the flight from the Capitol Conference in Southern California. Edgar, thanks so much for joining us here for a couple of minutes.
Good talking to you guys.
See you soon.
Joining us here on the ACSA Legislative Lunch Break, David Mishuk, partner over at Fagan Friedman Full Frost. David, give us the nuts and bolts of this Supreme Court decision as you've read, as you interpreted everything that's come out since Monday afternoon.
Obviously, this is a late-breaking decision from the Supreme Court. The Supreme Court clearly made clear its thoughts on the ultimate question, which is that any policy that prohibits staff from disclosing to parents a child's gender identity, where that policy has no caveats and is not narrowly tailored, it does violate parents' rights, two rights. One is the First Amendment free exercise right. This follows the Mahmoud decision that parents have a right to direct the religious upbringing of their child without interference. And second, a substantive due process right of parents to direct the medical decision-making for their children. And in both of those together create a situation where staff cannot hide from parents or intentionally lie to parents about their child's gender identity at school.
David, I have to imagine it's been a pretty busy 36 hours for you since the decision came down on Monday night from the Supreme Court. You've been presenting on this. I have to wonder, what are the feelings from the people you're talking to about the Supreme Court decision?
Well, obviously confusion and concern about where do we go now. Looking closely at the decision and looking at it in a narrow enough fashion. Again, this decision only strikes down any sort of policy of the state, and secondarily policies of school districts, which are in a lot of CSBA model policies on non-discrimination for students. It strikes down any direction that staff cannot disclose a child's gender identity without that child's express permission, can't disclose it to their parents without that child's express permission. It does not mandate that staff disclose a child's gender identity. identity. And in fact, Judge Benitez's decision in terms of the SAFE Act, AB 1955, it specifically says that its decision does not affect AB 1955. So in other words, the statute that prohibits school districts from mandating that staff disclose gender identity to parents still is on the books. All that said, there are implications of the Supreme Court case and implications of Judge Benitez's decision, especially in the language that's being used, that makes even that a little questionable.
David, let's talk specifically about the implications for school districts since this Supreme Court decision and moving forward now.
Absolutely. School districts that have on their books right now, and again, there's a CSBA model administrative regulation on non-discrimination for students, which includes language that implies, again, that staff cannot disclose to parents a child's gender identity at school if that child doesn't want staff to do so. That provision, whether express or implied, is null. School districts do not need to go out and have their boards immediately revise those provisions. Eventually, they will need to be revised, but they are unenforceable. The next step are schools and districts that have very well laid out policies and practices that have been instructed staff about student consent on disclosure when it comes to parents. Those school districts are going to need to tell their staff that staff are no longer prohibited from disclosing to parents a child's gender identity at school. This is about prohibition of disclosure, and secondarily, it's about not misrepresenting to parents when parents directly ask. That is another instruction that's going to need to go out to staff. If parents come to you and ask, is my child going by a different name at school? Is my child going by a different gender at school? Staff are going to need to be honest. And then finally, any child from a young child up to a teenager, where schools have informed that child that they will keep that child's gender identity confidential from the parents, those schools need to go to those children and tell them what is happening and help those children navigate what is the real possibility that at some point those parents may ask, and the school will have to disclose.
David, you alluded to it earlier in the conversation about the Safety Act in California. I wonder how California balances the Safety Act with the SCOTUS ruling.
I don't think the state's going to come out just yet in trying to balance the Safety Act. Again, we're at this place of no non-disclosure. What the obligation of school staff to inform parents in terms of students. I'm sorry, my dog is walking in the background.
See, that's the beauty of television, David.
It's the beauty of television.
Yeah.
So what the obligation of school staff is in terms of parents is left unsaid. I think that there is a real possibility that is sort of the next legal frontier. Yeah. Again, a lot of the language that's being used in Judge Benitez's decision, in the Supreme Court decision, it heavily implies a parental right to know.
David, finally, let me ask you about discrimination cases. It seems to me that the court has decided that discrimination when it comes to transgender students is okay if it guarantees parent rights. Your thoughts? Do you see it that way? Are we seeing the Supreme Court kind of change its way of looking at discrimination?
As a matter of federal law, I don't think the Supreme Court is changing the way that it looks at discrimination. As a matter of state law, gender discrimination, gender identity discrimination remain the law of the state. The prohibition against discriminating against a student's gender identity at school remains in place. All the policies and practices about honoring students' gender identity and their names and their pronouns at school, about instructing staff to address students in the way that they wish to be addressed, those remain 100% in place. What this case is narrowly about is about parents and parents of those students. And there is no case that I know of in which a parent can discriminate against their own child. And in fact, the Supreme Court and the Judge Benitez decision presume, and there is nothing wrong in this presumption, and this is a great presumption, that parents have the best interests of their children at heart. And parents are the ones who are best able to make decisions with regards to their children, even if parents disagree with their children's choices. And those choices can be anywhere from social choices to friends to identity. And that is a part of both religious freedom and parental freedom in terms of student upbringing. So in terms of discrimination against student gender identity, we may not discriminate against a child's gender identity. Where this may come up eventually is when a parent instructs a school not to honor a child's gender identity, and in a strict legal sense, it is unlikely discrimination. The child is a minor. Their parent has a right to make choices on that child's behalf. There are other ways that schools should, like any child, support that child's social emotional well-being and development. But in this narrow sense, that would not be discrimination.
David Mishuk, partner over at F3 Law, one of the busiest lawyers in the state of California right now. David, please try to get some sleep in the next few days. We appreciate the time, and please come back soon.
Thank you so much. Thanks for having me.
And I see that there are a number of questions over there in the chat, and as we mentioned at the top of the show, David has been doing presentations throughout the day on this specific topic. But one thing that he has made mention of is the clarity piece to it and what districts do now. So I see a couple of questions that have come in there on the chat. What we want to do is we want to collect as many questions as possible and have David just take a deeper look into what you need to know. And as soon as we have that created, we'll I'll cut and paste all of them. We'll put those onto an email and find a way to get that information to you next week. But certainly, Michael, David had plenty to say, and I think it's safe to say that there's a lot that we don't know, a lot of clarity that needs to come. I don't know how the state of California, how the Department of Education is going to respond to any of this, but we will certainly see over the next couple of weeks what comes from that. Go ahead.
I will say, I mean, we do have a statement from a spokesperson for Rob Bonta saying we remain committed to ensuring a safe, welcoming school environment for all students while respecting the crucial role parents play in students' lives. But to your point, Edgar said the same thing. We're kind of waiting on next steps from the state here and the legislature, for that matter, of what comes next. Are there ways to get around the Supreme Court ruling that still allows for some I don't know, middle ground on this? That's the stuff where it's just too early, and we are very much in the early stages of this.
Yeah, and again, you heard Edgar at the top of the show talk about what role does the state legislature play in this moving forward, and so certainly some stuff for us to pay attention to moving forward. Want to tell you a little bit about a couple of things we have going on. First, want to tell you about our Equity Institute. This is the 2026 Equity Institute titled Equity for Real, Anchored in Integrity When the Tide Shifts. That's March 25th through 27th at the Westin in Anaheim, the 2026 Equity Institute. There's a QR code on your screen. You can click that after the show is done, or you can visit our ACSA website, axa.org/professional-learning, which gives me the opportunity to show all of you the brand new ACSA.org. This website, we launched it this weekend, is a great website, easy for you to track through your professional development, your access to our advocacy work. You'll find links to the ACSA legislative lunch break. I can't believe I just said the incorrect word there, Michael. And then you can see our leadership right there. Brand new ACSA.org to go ahead and check that out. Folks, if you like what you've seen here on the live and interactive ACSA legislative lunch break, we invite you to like us and subscribe to us. When you subscribe to us on YouTube and you turn your notifications on, you will get instant alerts when we're about to come on with breaking news, and then when Edgar and I are here for our regularly scheduled Wednesday show. And if you have great stories happening in your school communities, we want to tell those stories too. Go ahead and send your news releases, your photos, your talking points to our EdCal editor, Michelle Carl, at mcarl@axa.org. Want to also let you guys know about this. We had planned to have a legislative update for you with a number of bills moving through the Capitol right now on reporting, 60-day substitutes, the lawsuits against school districts. We're going to bring that to you on our next episode of the ACSA Legislative Lunch Break, because a lot happening over at the state capitol right now. Folks, thanks so much for joining us here on the live and interactive ACSA Legislative Lunch Break. We are live and interactive Wednesdays here on ACSA Facebook and ACSA YouTube. Have a great rest of the day and rest of the week, and we'll see you next time.